good evening, everyone, and welcome to LawSikho's thorough newspaper analysis for the 1st of August 2023. Now, today we have one editorial article which has been taken from the Hindu, and it talks about in Article 370 hearing, the original text and the spirit counts, which basically is a small summary of what happened regarding Article 370 and why it is to be heard by the Supreme Court again, almost 4 years after it was abrogated. For the second and the third segment of the day, we will have the news update and the legal news. So, the title of the editorial is In Article 370 Hearing, the Original Text and Spirit Count. Now, the issue is in light because the Supreme Court is to begin hearing on the oral arguments of the case concerning Article 370 of the Constitution tomorrow. And this goes back 4 years to the presidential order, which eventually, after a lot of tussle, led led to the development of significant changes in which we lost the state of Jammu and Kashmir and Ladakh, and they were divided into two union territories. Now, when we talk of Article 370 and its history, we need to remember that the Indian Independence Act of 1947 allowed the Government of India Act to serve as the interim constitution until the country had adopted its own constitution. And this particular statute permitted the princely states to accede to India by executing an instrument of accession. And in the case of Jammu and Kashmir, this particular the clauses laid down in the instrument of accession were later penned down under Article 370, which stipulated that Parliament could legislate for Jammu and Kashmir only over matters concerning external affairs, defense, and communications. But the thing is that after 1957, when Jammu and Kashmir's constitution came into force, its constituent assembly, which was the body which was supposed to take the decisions in favor or against, like it was supposed to take the decisions regarding Jammu and Kashmir. So this was replaced. It was disbanded and replaced by the Legislative Assembly. Now, Article 370, however, remained unaltered. Its chief drafter, Gopalaswamy Iyengar, had described the State Constituent Assembly's recommendation as mandated by Clause 3 to Article 370 as a condition precedent to any effort at abrogating the provision. And so, while Article 370 provided a set of limitations in this regard to the central government in abrogating the entire provision, and by that action, abrogate the conditions under which Jammu and Kashmir had signed the instrument of accession with India, there were certain limitations in that. But the central government chose to bypass these set of limitations by looking into a specific clause of the constitution, that is Article 367, in order to accomplish its means. Now, this has since then, ever since the presidential order came out, this has been called a Colourable Exercise of Power. Now, why so? So if you leave aside everything else and consider the consequences only, the Jammu and Kashmir under President's rule, the governor came to act not only as the state's legislative assembly, but also its constituent assembly. So when we say that the president had put out his order and the Jammu and Kashmir governor had gone forward and assented to it, it is basically the central government assenting to its own order. Since the state's legislative assembly was already banned, it was the governor that was acting in their place. Now, if and based entirely on this argument, the petitioners have argued that the representative democracy is a basic feature of the Constitution, and any interpretation of the Constitution must strive, they say, towards enhancing this value. Further, the framers of Article 317 were of the view that any overriding of the provision can only be done through the procedure contemplated in Clause 3, that is, with the blessings of the state's constituent assembly. Once the assembly stood disbanded, this option ceased to exist. On the other hand, the union, for its part, has argued that this is not the first time that different provisions of the constitution have been made applicable to Jammu and Kashmir. There have been numerous instances of presidential orders made through the erstwhile Article 370 Clause 1D by securing the concurrence of the state government wherever necessary. But as the petitioners have pointed out, there is a difference here, and this might well be why the Supreme Court probably wanted to hear the case again. And this stands out as a very important point, is that previous presidential orders, including the order of the controversial Article 35A, were made without altering the text of either Article 1 or Article 370 in any manner. Now, this is critical because on a conjoint reading of Clause C and D of Article 370 subclause 1, what seemed to follow was that the president could make applicable to the Jammu and Kashmir any provisions of the constitution, that is, provisions other than Article 1 or 370, with modifications or exceptions as deemed necessary. Now, India's constitution establishes a system of governance where power and authority are divided between the union and the states. And the Supreme Court has gone forward and routinely described this structure, this federalism idea that is enshrined in our constitution as an essential component of this Indian constitution. Therefore, when the arguments are being heard on the validity of the decisions made with regard to Article 370, the court will have to lay emphasis not only on the text of the provision's original version rather, but also by the spirit that pervades through the document's basic structure. And from tomorrow, I guess the entire nation will be looking at what the Supreme Court has to say regarding Article 370. So, with this, we move on to the news updates for the day. Firstly, we have BSNL's Shivendra Nath to be set the next CMD of EPIL. Shivendra Nath, a 1994 batch officer of UPSC, has been chosen by the PSCB panel to assume role and chairman director at Engineering Projects Limited India, a public sector undertaking PSU under the Ministry of Heavy Industries and Public Enterprises. Nath began his engineering career in 1994 after being selected through the Union Public Service Commission as the engineering project manager of P&T Department, Indian Engineering Service. Nath has been serving as chief engineer at BSNL from September 2020. Previously, he held the position of superintending engineer at Naya Raipur Development Authority until January 2021. At present, he is working as the senior general manager at the BSNL. Secondly, we have India, AI, and Meta have signed a MOU to foster advancements in AI. India AI, which is an IBD under the Digital India Corp, and Meta India have signed a memorandum of understanding to establish a framework for collaboration and cooperation between the two organizations in the field of artificial intelligence and emerging technologies, which include Meta's open source AI models available for use by Indian ecosystem. The MOU was signed by Sri Abhishek Singh, CEO of Indian AI, and Sri Shivnath Thukral, Director and Head of Public Policy, Meta in India. We also have Professor Ganesan Kannabiran as the new NAAC director. Now, the National Assessment and Accreditation Council, which is the NAAC, you must have had heard of the NAAC accreditations that are given out to colleges. Now, he has Professor Ganesan Kannabiran was announced as its director. The appointment took place on the 28th of July as per the official statement from NAAC. Professor Kannabiran brings with him a rich experience of over 30 years in the education sector, having served as a senior professor of information systems at the National Institute of Technology, Tiruchirappalli. Throughout his career, he has held various leadership positions, including the Dean of Research and Consultancy and Director in Charge at NIT Trichy and NIT Puducherry, respectively. Next up, in a rather important development, Indian Navy ends colonial practice of carrying batons by personnel. In line with the government's direction to shed colonial legacy, the Indian Navy has ended the practice of carrying batons by all its personnel with immediate effect. In a communication issued by the force, the Indian Navy said, with the passage of time, carrying of batons by naval personnel have become a norm. The Navy has now directed that a ceremonial baton be suitably put in the office at the head of organization of each unit, where it will be handed over as a part of change of command. In another instance for recognition for what Ratan Tata stands for what he does for the society, Ratan Tata to get Maharashtra government's first Udyog Ratna award. The Udyog Ratna award is a state level award given to individuals who have made outstanding contributions to the industrial sector of Maharashtra. Ratan Tata is being awarded with this award for his contributions to the growth and development of the Tata Group, which is one of the largest conglomerates in India. A meeting was held regarding this by a committee comprising of Chief Minister Eknath Shinde, Deputy Chief Ministers Devendra Fadnavis and Ajit Pawar as the Industries Minister. Next up, we have Punjab tops beneficiary list under Atmanirbhar Bharat Rojgar Yojana. Punjab is the leading beneficiary among states under Atmanirbhar Bharat Yojana, a scheme initiated by the center during the pandemic to give a fillip to formal employment. According to data, 1 in every 5 active employees provident fund subscribers in the state joined the workforce. Himachal and Rajasthan have come up as the second and the third state in this list, respectively. We also have Bhutan announces successful elimination of rubella. Bhutan has announced the successful elimination of rubella, and on 21st July, the World Health Organization recognized Bhutan's effort to tackle this highly contagious and potentially devastating disease. In the past 20 years, Bhutan's health workers have worked tirelessly and fought against rubella, also known as the German measles, according to the report. This infectious disease poses a threat to those infected and also causes severe complications for pregnant women, resulting in irreversible birth defects in newborns. Now, for the international segment of the day, we have World Aquatics Championship 2023 concludes. The 2023 World Aquatics Championships took place in Fukuoka, Japan from the 14th of July to the 30th of July. At the end of the championships, Team China leads with a medal tally of 20 gold medals, followed by Australia and USA in second and the third place, respectively. We also have Formula One Max Verstappen secures his 8th straight win. Max Verstappen made light of a 5-place grid penalty to reel off an 8th consecutive victory for his invincible Red Bull team at the Belgian Grand Prix on Sunday. The defending double world champion and runaway series leader came home 22.305 seconds ahead of teammate Sergio Perez. Now, with respect to the legal updates, we have ex-parte order can be recalled at behest of the necessary party, that is non-party in a case, Allahabad High Court. Now, the Allahabad High Court, in the case of Tarakeshwar and 2 others versus the state of UP and 5 others, has held that every court and tribunal have inherent power to set aside an ex parte order as it amounts to procedural review and is distinct from the statutory power to review a case on merits. Justice Yogendra Kumar Srivastava held that Revenue Authority can recall an ex parte order passed without grant of notice or opportunity to the affected party to correct the procedural defect for doing justice between the parties. For the second legal update, we have first wife can file application under Section 11 of the Hindu Marriage Act for declaration of husband's second marriage as void. Now, the Allahabad High Court, in the case of Garima Singh versus Pratima Singh and another, has upheld the right of the first wife to file an application under Section 11 void marriages of the Hindu Marriage Act 1955 for declaration of her husband's second marriage as void. On the harmonious reading of the Family Courts Act 1984 and the Hindu Marriage Act 1955, the bench comprising of Justices Soumitra Dayal Singh and Vinod Divakar held that if the first wife is deprived of seeking a remedy under Section 11 of the Hindu Marriage Act, it would defeat the very purpose and intent of the Act. The protection offered to legally wedded wives under Sections 5, 11, and 12 of the Hindu Marriage Act would become insignificant in such a scenario. So this was all for today. For free study materials and TNA PDF slides, please join our Telegram channel, the link of which you can find in the description given below, or you can always scan the barcode that is given on your screen. Don't forget to subscribe our channel on YouTube to stay up to date with the thorough newspaper analysis as it comes out every day. Thank you.